Hello and welcome to IGPP's panel discussion on draft digital personal data protection tools. We have with us as guests to speak on this issue Ms. Nappinai, who is Senior Advocate of the Supreme Court of India and is founder of Cyber Sati, helping citizens to deal with the laws in the cyberspace particularly. We have with us Dr. Amar Patnaik, who is former member of parliament, has been part of the JPC on the Personal Data Protection Bill, and was also part of the Rajya Sabha's committee on study the effects of pornography on citizens. And we have Ms. Usha Rengaraju, who is founder of NeuroAI and works at the intersection of innovation and industry. Thank you so much, all of you, to join with us. I just want to make a statement from the press release by the PIB on the 5th of January, when releasing the draft rules, which says the draft digital personal data protection rules aim to safeguard citizens' right for the protection of their personal data. These rules seek to operationalize the Digital Personal Data Protection Act 2023 in line with India's commitment to create a robust framework for protecting digital personal data. Sir, I want to come to you first and to request you to let us know whether the rules which have been framed, the draft rules, do they serve the purpose of India's commitment to create a robust framework?
Thank you so much, Manish ji, and thank you for inviting me to this panel discussion. I would begin by saying that the joint parliamentary committee which discussed the 2019 version of the bill underwent, the bill itself underwent a complete change the way it was introduced later in 2023. But the JPC did go through the process of hearing out from all stakeholders, both the government fiduciaries as well as non-government fiduciaries from all sectors. And so had a fair amount of effort put in to draft the new bill, which was finally passed as the DPDP Act 2023. The basic difference is that the current version of the bill, that is the Act itself in 2023, is completely based on the large or the broad principles that have been set out in the Puttaswamy judgment. So the details of implementation and operationalization, which was there in the earlier version of the bill 2019, having been taken largely from the EU GDPR, has now come in the form of rules, and that was expected. So the rules are now framed for operationalizing the 2023 Act, and obviously cannot go beyond them. It specifies or gives detailed explanation of how to execute that particular provision, let's say relating to consent, relating to processing of data inside, outside India. The principle was there in the main act, and the rules have basically elaborated on it. Now, to your question as to whether the draft rules are robust enough to address the concerns of India and the Indian citizens or the Indian data principles, I would say that we have to evaluate whether the Act itself was adequate or not, or that it had significant gaps. And then next step comes that the draft rules, whether the way it has been structured to operationalize the Act, are adequate to achieve the objectives of the Act itself. On the first part relating to whether the Act itself was adequate, I have spoken about it in the Parliament when the bill was getting passed, that it doesn't take into account reputation loss in the loss definition. It only talks in financial terms. That it whereas purpose limitation and data minimization has been mentioned, I think probably there's a larger window which has been left for the government fiduciaries, not really the only exemptions part, but even the window of or a kind of a diluted version of the act is being applied on the government fiduciaries, whereas it is to be recognized that government fiduciaries are the one who are the largest collectors of data, number one. Number two is that if you look at the fundamental rights violation cases in the constitutional courts, it is largely against government bodies only. So if there would be an infringement of the right to privacy as enshrined or as interpreted by the Supreme Court and as given effect to in this act, then it would largely be against government bodies. So they, I thought, should have been held to a stricter interpretation of the privacy law. The third thing was that, there's more the independence of the board, the lack of graded penalty, the lack of stricter penalty for children and data of women. Many such things I had spoken in the parliament. As far as coming to the draft rules thing is concerned, there are two things that had happened. I had mentioned over there that penalties against misuse or abuse of data of children and women have to be put in a separate footing and should be made stricter. So I think they have not been able to obviously change the original act provisions because it's not possible without going through another amendment. What they have done is that they have explained that the children's age consent has to be a verifiable consent from the parents. I think this is one area where I feel that operationalizing it in real terms would be really difficult. And to prove a case in the court that a data fiduciary has not followed this particular provision would probably be really difficult. Of course, I think it will be an iterative process later to bring in changes to make it something which can be actually verified, by an enforcement agency. The point is that you can have a grandiose ecosystem developed for implementation of policy, but if there is a infringement, if there is a violation, whether it can actually be enforced in the court of law. Now, that is where I feel that the privacy law will have a lot of new issues coming up during the enforcement process when it is spread out across the country, and particularly against government data fiduciaries. The second aspect is consent. That was also spoken. I had spoken about it at the time of the passing of the Act, the 2023 bill. That the consent has to be obtained in a language that is understood or that is preferred by the data principal. So all the Indian languages would be required to be given, and in such simple language that he can be informed of that particular consent while giving consent. Now that may be a heavy compliance cost for a number of data fiduciaries, particularly the smaller ones and the startups and the MSMEs. So I think that is one. The third point is that in a country with large number of, I think some report had come out that in 43% of the schools itself, we don't have computers, the latest report from the Education Ministry. And despite large-scale digital adoption in our country, the access to digital devices is very poor in many of the rural areas. So when you say that I have designed an act which is digital by design, it may sound good. It may be a good exercise because it brings down the cost of implementation. One has to be cognizant of this digital divide. And because of this digital divide, the issue that would come up is that how do they exercise their right in case their data is breached? In a consumer, in a similar kind of situation in the consumer courts, you have district level courts. So people can go to a district court and, file their complaint against a good or unfair trade practices. But here, you don't even have a state level authority. And this is what, again, I spoke in the parliament. I've been writing about it. So how far it will be able to serve the poorer people of India, whose data is taken and breached and maybe used against them in a manner which, or for a purpose for which they are not given consent, is something that one has to think about. The Consumer Protection Act, again, has sets out a separate corpus for consumer education and spreading the consumer awareness. I think similar kind of situation is not there in this act or the rules, which probably has to be thought about. Last point is privacy by design. I think privacy by design is something which was a separate chapter in the previous version of the act and also in the EU GDPR. In the current version of the act and current version of the rules, it is just not mentioned. The assumption is that if data fiduciaries have to be responsible in protecting the data of the data principals, they would have to do that. That is the kind of argument that the ministry is trying to make. But I think if a mention of privacy by design would have been there or would have been laid out, at least in the rules, that is what I pleaded in my debate in the parliament, if not in the act. What would have happened is that it would have developed an ecosystem of privacy all across, because currently this is being sponsored by the Ministry of IT, but privacy is not an issue of only IT. Privacy will be an issue in agriculture, in health, it will be in several areas. So an ecosystem has to develop, and that would have happened probably if privacy by design could have actually come in as separate place of prominence in the rules. I think these are my, as far as I think of important gaps. I think these are the ones. Thank you.
Thank you so much, sir. And I'm so thankful that you have beautifully, I would say, give a very relevant brief of the issues which these draft rules have. I want to come, and it has made our job easy in a way. I want to come to Ms. M.S. Nappinai, that the aim of the Act is also to seek to protect two citizens' rights in accordance with the law. Do you think, from an overview, although a lot of issues have already been just described by Dr. Patnaik, how do you see it, whether it will be able to protect citizens' rights and to what extent?
When we speak about personal data protection, just the very thought of implementing something of this nature for India with its large populace does pose a huge problem. So we are also jumping into the fray in terms of introducing a law for this quite late. So we are now trying to measure up to a golden standard of GDPR and beyond, and at the same time trying to implement something across the board for India at a fairly belated stage. So when we look at the way the law has evolved, Mr. Patnaik had already laid the foundational process in terms of speaking about the 2019 draft. It goes back to one more draft before that of 2018. And of course, the principles laid down in Puttaswamy's judgment and the data principles which have evolved with the EU directives and thereafter the GDPR and the other data protection laws from across jurisdictions. So when you compare it with that, what India seems to have postured with its DPDP Act, and I'll use the shorter form for the sake of brevity, when you look at the Act itself, when it gave a bare bones Act, it said we are going on a principles-based methodology and we would be fleshing it out in terms of rules. So when you look at the first level of the first look of the first set of rules that have come out, if you ask, are these sufficient? Naturally, the answer would be a resounding no, because both the Act as well as the rules are still bare bones. It only deals with, if you look at the Act, and if you just do a search of the word prescribed, you'll see how many times it's been repeated and how much of that has been covered in the first set of rules. And that itself will give you an idea of where the gap lies. So first and foremost, a principles-based act was relying predominantly on rules. So, do the first look of the rules give you all that was needed to flesh out the act? Certainly not. Should it have done? Not necessary, because we can always keep building rules as we go forward. So, to just evaluate the efficacy of the act or the rules based only on the first look may be unfair. But having said that, where to what extent do the rules really help us to implement the act? Because right now, our concern is we started with 2017, Puttaswamy, and I would say we actually started in 1998. One of the earliest cyber laws India was evaluating was for personal data protection. We did not opt for that. Instead, we went in for a more generic Information Technology Act, which surprisingly did not contain the provisions for data protection, and that was introduced in 2008. So our wait has been fairly long from 1998 till date, and even the minimalistic provision that was introduced under 43A of the IT Act and 72A has not seen much in terms of enforcement. 43A would have gone before the adjudicating authority. If you look at the kind of cases that were going before that, not one of the instances of data breach really went before the adjudicating authority. So we are now looking at starting off an implementation process, and a 2023 Act is still remaining to be implemented because the rules are awaited. So finally in 25, if we got a first look at the rules, I would say it is a happy new year indeed. And it would be even happier if the act is actually implemented, good, bad, or ugly, whatever we have on hand. Because let us first get our first level of protection, and then we can worry about more. Otherwise, we are simply debating hypothetically instead of actually having our rights protected through a due process. So that would be my first statement off the bat. Going forward, these are my preliminary thoughts on the Act and the rules as a combined reading. The first and foremost, what I mentioned earlier about prescribed and what we have, there are certain things which are bare necessities which has to be addressed at a first level, like setting up of the DPDP board, then the consent manager, etc. And all of these are addressed under the rules. So the way I look at it is, once the board is set up, I expect or anticipate that we are likely to get a fairly more robust set of rules, or at least procedures or processes, which will help us in understanding how a particular complaint is to be submitted, how it will be dealt with, what will be the methodology for enforcing penalties or implementing penalties, etc. But the one concern I have there is the Act was silent on providing compensation for the victims, the data principals, who either may be complainants or who are identified as victims upon a complaint that the board would be investigating or inquiring into. So what happens to those victims? Where do their remedies lie? Because with the DPDP Act getting enacted, 43A has been repealed. Therefore, your remedy before the adjudicating authority for a compensation for your personal data breach no longer lies. So where is the alternative? The civil court's jurisdiction also has been removed under the DPDP Act. Therefore, it is only right that a clear process be established to clarify how and in what manner a data principal or a victim data principal can get their compensation. And I think this is particularly critical when you have introduced a very unique, this is not something we should have been unique on, quite honestly. We have actually introduced duties of a data principal. And in that, no debate took place sufficiently, according to me, on this, that you have actually introduced penalties against a data principal. And if you look at the law, it is so ambiguous in the manner in which it says that this penalty will be implemented. See, to others, when you look at 250 crores, etc., 10,000 rupees may seem very small. But when you're talking about an individual, it's a lot of money. And it becomes what we've been talking about again and again, right? Chilling effect in terms of deterring even a complaint, because nobody wants a fine of 10,000 rupees being imposed on them. So you have a fine, but you don't have compensation. So I think that's quite unfair. And the ambiguity in terms of even the imposition of fines for the duties of data principals is something that rules need to address, because it merely says if you violate any extant laws, if one is very clear, if you give false information, that is fair. But to say if you violate any extant law, how is an individual supposed to know what is that law which he is violating, which is going to result in a penalty? There has to be a direct nexus between the two. So I've actually jumped to something which I would have come to as point number 5 probably, but this is very close to my heart, and I think this is going to be critical for each of us as individuals. And therefore, I thought I should mention this. Again, something that I think impacts every single one of us as individual users is the exclusionary clause that is there in the scope. I quite honestly believe that not enough emphasis has been given to that. If you look at the scope of the Act, it clearly says that data, personal data shared in public domain is exempted. And the illustration that is given there is that if you share your personal data in, for instance, a blog or a social media post, this is the exact wording used. So social media posts are exempted from personal data protection, which is shocking because that is not our understanding of personal data protection. Even if I share my data in public domain, I should still have the right to recall it, right to be forgotten or for erasure, etc. This is how we looked at it. Unfortunately, the Act clearly excludes this. So, when you talk about rules, there are two aspects which I believe would be covered. One is what is my right and how am I going to enforce it? And two is what is my right, even in the context of such exemptions, in terms of a clarificatory note. Now, those clarifications are completely missing, including, and I'll explain why I'm saying this clarification was critical. And I was told that this would be part of rules, unfortunately, in some discussions and debates, but unfortunately, it has been sadly ignored. Now, what exactly is the clarification we needed? When you look at the exemption, it is only personal data that is shared in public domain. So the user would have signed a contractual term to be part of that public domain platform. Now that personal data still carries personal data protection. That clarification is really needed to ensure that our rights are protected. Now that's missing. Secondly, the exemption also says it is your own personal data, which if you share, you don't get the right. So that means that if I share third party personal data, then that still gets data protection. Again, that clarification and the process for implementation, that is very critical. See, we are dealing with a populace which personally does not even understand the relevance of data protection. We are used to asking very personal questions of our neighbors, our friends, our non-friends, acquaintances, non-acquaintances, everybody, right? So suddenly we have to change our DNA to understand what is data protection. And in that process, if you have this kind of an exemption which doesn't clarify, then you're actually diluting my right. So moving forward from that very quickly now, child rights. I must say that I was pleasantly surprised with the rules in terms of exemptions, because I was very worried about subclause 3, which says that the central government may exempt a data fiduciary through rules. So I was worried about that kind of an open-ended right being given to an executive through delegated legislation. But if you look at the schedule in terms of exemptions, I feel it has been done in a very fair and balanced manner. So that is a good thing. But in terms of the kind of parental consent process that has been set out. Often everybody talks about government surveillance. Now, let me just take a pause here to explain why do we need the act. You asked me about fundamental rights and if our rights are protected, and Mr. Patnaik talked about how most law cases are also filed for protecting rights against the government. I can move courts for protecting my privacy right against a government even without the DPDP Act. But I needed the DPDP Act to protect my rights against corporate surveillance. Right? So it is critical for us to have the statutory right to protect a fundamental right against any person who is violating my right. Now, who are the persons against whom I can exercise this right? That the law sets out. So when you have a law which talks about parental consent, and it is talking about sharing of personal data and triangulation of that personal data with family members, which is then going to reside with a corporate entity, it is really important to also have purpose limitation in such a way that a corporate is now not going to take advantage of this to collect more data from me. And that is more data about a child as well as its parent, as her or his parent, right? So therefore, I feel that protective measures, that ring fencing, that ought to have come in through the rules is missing. And I hope that something is built into that. And the simplest methodology would be for data deletion upon completion of that purpose, which is clearly set out as only for verification, right? That's a very simple way out. Now, moving forward to just two more points I want to make. I won't touch upon consent beyond what I have already talked about in terms of scope. I would actually limit it to just one more point and then answer any more questions that may come up. Ultimately, we spoke about the EU golden standard, right? It may not be a golden standard, but right now, that may be the best we have. So, why is it that when we have a precedent before us and we already had cases filed and pending before courts where we asked for parity with EU citizens in terms of an opt out provision without losing a service, why is it that we are still not given that opt out provision under a new law? The old law did not have it, and it was very critical for the new law to have it. And what am I speaking about? So whenever you sign up for a platform, or when a platform shares a new terms of service, or when you go to a site and it asks you for permission, the cookie permission, it will give you these options in terms of accepting all, rejecting all, or saving your preferences or choosing whichever. So if you go to choosing your preferences, only those essential cookies will be something you cannot choose. It will already be pre-chosen for you. But the other options for advertising, etc., are things you can choose and say, sorry, I reject everything. And you will still be entitled to access that website or that service. Now, what I mean by an opt-out on par with EU is, even if I say no to all the cookies except that essential cookies, it cannot mean that I will then be deprived of a service. Just because I refuse your privacy policy does not mean I will not be given that service at all. Now, that's a criticality that India needs, because we are otherwise given the Hobson's choice of saying take it or leave it, because I'm giving you a free service. EU said, sorry, no, that's not possible. Whether you're giving me a free service or not, you cannot violate my privacy. Now, that is what I mean by protecting my fundamental rights without compromising my choice. And that is built into Section 6 in a way which could have been elaborated upon and needed elaboration. That's still missing in the rules. I hope that will come out pretty quickly. But all said and done, as I said again, I hope that, given the very short time that the government has given for the public consultation, we will see the light at the end of the tunnel sooner rather than later. I can understand that for certain things, a longer period of time will be given for corporates to comply. But it should not be that we are still going to wait for the DPDP Act to be implemented for the next year or 2 years. It should be just a few months, hopefully.
Thank you so much, ma'am. Ms. Usha Rengaraju, the another promise which these rules make is to bring a fine balance between innovation and regulation. Do you think, from your perspective, from perspective of industry, does it suffice?
Yeah, I think that's a very tricky part because there are a lot of draft rules which might, prohibit innovation in a certain way. But for a country like India, I'm not sure if it will act as a blocker, because one of the rules which acts as a blocker, especially, is cross-border data exchange, especially when it comes for, because I used to work for a lot of US projects. So there it used to be a lot of very difficult, to deal with data, because the data cannot be transported outside of United States. So that's a very difficult thing for us. And so that way, there is a lot of restrictions. So the citizens who have to work on it have to get US visas, and only then they can go to United States and then they can work. So there are a lot of complications which comes when dealing with projects which are especially, requires cross-border transfer and things like that. So for a country like India, I don't think that will be a problem. The reason is, outsourcing predominantly happens here. This is the outsourcing hub. So, I mean, unlike United States, we are not dependent on any other country for data processing, and the predominantly of the world's data, the outsourcing happens here, since we are an outsourcing and service hub. So for us, this cross-border data exchange may not, act as that kind of a blocker as it is acting for countries like United States, Europe, and things like that. So again, there are a lot of clarity which requires, you have, for implementation of all these things, there's a lot of clarity which is required. For example, they say there are exemption of certain startups and government agencies which can use these data and things like that. There's not much of clarity on what constitutes good research, right? Like, who can actually access the data? I mean, there's not much of a clarity on who, the definition of all these terms. And so that has to be taken into account. In a way, all these, it is, I'm so happy that there's a lot of there's a lot of imposition of fines on companies which violate all these data protection things, because a lot of times in India, the data protection is taken very much granted, and the companies have been violating left, right, center, and they've taken, but they cannot do that in countries like United States or Europe. They're very, very cautious, because when we work in a project, because I've worked in a lot of large scale implementation projects in banking sector and things like that. So they used to say this project is going to be deployed in India. So there is no security restrictions. There's nothing. We don't take any of these, restrictions into account. We just take it for granted without any provisions and things like that. We just do a bare minimum implementation, go live in production without bothering much. But when it comes for UK or when it comes for Europe, they have to like literally spend 3 to 6 months, debating on the algorithms, because they say, the European government agencies don't allow this, don't allow that. So there's so much of thought process with the same company which is implementing for multiple regions. They put it into consideration for European implementations, or if they have to implement the same project in US, they do a lot of thought consideration. They don't do any of it in India. I've seen a lot of large scale implementations which involves multiple countries. So I think in a way, like putting restrictions of like imposition of fines like 250 crores and all these things, it is good. Now the thing, people will start taking these things seriously as well. But again, like when you see the implementation side of it, there's going to be a lot of different platforms, lot of different devices which are going to come into play. So having a single protocol or a single mechanism which will work across multiple devices, things like that might be very difficult to achieve. So the rules are great, but technical implementations of it and feasibility of it is going to be very difficult. And the cost of implementing of it is also going to be a challenge for a country like India. And most of the startups which you see, they are surviving on a very meager budget, just getting their POC out and things like that. These kind of implementations will put a lot of infrastructure overload on them, or cost overload on them as well, for them to implement a consent management system, implement a lot of these kind of things which they're not even bothered at this stage, when they are doing. There are like pros and cons of the act. There are some players who might get benefited, there are some players who might it might act as a blocker for certain players, because there were like discussions which we were having in the last 2 years in the AI and data science community, what these kind of acts might impose for a country like India. So if you see, 90 to 95% of the AI professionals, they feel this might act as a blocker for them, because at this point of time we don't have many restrictions, and that's why there's like a lot of innovations and interesting stuffs coming from India. And when there are too many restrictions coming out, then there are majority of things technically, technological innovations might take a hit. So that is for sure. For example, if you see, there are a lot of large language models. When you take AI, you have large language model, generative AI. There are a lot of interesting large language models which get released in India and in United States, but they are disabled for European citizens to access it or view it. So there's a lot of technological innovations here in AI. If you see, the technological innovations in Europe is too slow because of the too many rules and regulations in European acts. The pace at which the technological innovation happens is like very backward. So it is like backward compared to India. India is like super fast in terms of AI innovations, at least capturing them and at least using them. We do not have that kind of a sufficient funds to implement large language models from scratch. We are not like still at a stage where we can put billions of dollars to build our foundational models and things. So not many players in India can do it, but still in terms of adopting and implementations of several top technologies, we're still way ahead compared to Europeans and all. But putting all these regulations and restrictions definitely, might slower the pace of technological innovations and things like that. And there's definitely going to be a lot of technological complexities in the implementations and stuff as well. And there's a lot of things in the draft rules which is not very clear as well. Incidents reporting, like 72 hours within this incident breach, it has to be reported. And there are different categories of breach as well. So there's a lot of ambiguities when it comes for the draft rules. So all of this has to be clarified as well. And when it comes for security mechanisms, implementations of security rules and protocols are always a difficult challenge for any organizations, even in the current state of thing. So I think they've just mentioned the basic cryptographic algorithms and things like that, but there's a lot more clarity which is required on the implementation of security protocols and things like that. Those are areas which have a lot of inconsistencies, which has to be like elaborated even more, because the technological implementation, you can put rules, but how do you implement technologically? So there, I think there shouldn't be any ambiguities, these are things which should be taken care of. So this is my broad thought process in the perspective of technological perspective is what I would say.
Thank you so much. I think what you have mentioned about the limitations which this law might put on innovation also brings us to our next question, which I want to bring to both of you, particularly Dr. Patnaik. Like, when we say digital nagriks are at the center of the digital ecosystem. So on the one hand, we are looking at the innovation. On the other hand, we also want to protect the right. Where do we reach a kind of a balance between the two, and how it would be done? I just want to take another example from the government side. There was a breach in AIMS like some time back, and who is responsible for it? The breach in data in AIMS. Like, it's a government fiduciary, but it definitely source out their work. So where does it lie, and how are we protected as citizens?
Yeah, thank you, Manish. So I think let me make a couple of points before coming to your question. That is, as Madam Nampi was saying, that the rules is just one stage below the acts which have now come, the draft rules which have come from the government side, supplementing again the highest level that it is a fundamental right which has been enunciated by the Supreme Court. What I think is going to happen is that once the Data Protection Board is set up, the board will come out with regulations, standards of practice, SOPs. Now, if you look at the 2019 version of the bill, and which was taken from the EU GDPR, you will find a lot of that probably getting into the actual operation aspect, into the regulations that will come out by the board. And then only we can say that the full ecosystem has been developed. Then number two, the reference to the IT Act, where there was a little bit of a mention. Once the Digital India Act comes, then I think a lot of issues relating to the place artificial intelligence will have in the entire ecosystem, balancing innovation and regulation, I think will find place there. The third point is that if you again look at the 2019 version of the bill and the again EU GDPR, the Data Protection Board would be conducting, I think, inspections and audits. So that will take care of the adequacy of provision, reasonable level of security measures set up to prevent a data breach. Now, to coming to a question, what happened in AIMS was basically not a data breach from the point of view of the data fiduciary who has collected the data, having a weak internal control system resulting in data breach, or deliberate, breach or deliberate release of such data collected from patients for other purposes other than the one for which it was collected. What happened over there was a cyber security issue of a hack which had happened. There, of course, the two questions that will need to be evaluated by the Data Protection Board is whether, after inspection, it is found that the data fiduciary, that is AIMS itself, was responsible for this because it had weak controls, or it was actually a hacker who had used a system or who used a procedure much more sophisticated to hack into the system illegally and collect the data and use it for other purposes, in which case it will be a criminal offense against the hacker, and it's a cybersecurity case. But the next step would be, and I think this is again another lacuna which has to come into the ecosystem in whatever form, as to that in such a case, the data which has got breached of the data principles against the wish of the data fiduciary and against the wish of the data principal himself, how would it get again protected? Or how would you protect himself against the harm that could probably be perpetrated against the data principal by an unknown hacker who has collected this data illegally? So these issues will have to be thrashed out. And as I said, that Data Protection Board would be more in the process of actually operationalizing this. The rules are only providing a sense. I would also answer this question relating to 21 or 23 places where there is a mention of to be prescribed. It is actually to be prescribed not just by rules, it could also be to be prescribed by regulations, which will be the next step, and which I think the Data Protection Board would do. The other point relating to high compliance cost upfront, maybe innovation taking a backseat because of these. My answer would be that if I take a similar case in case of individual freedom versus innovation in some area, the courts, the law of the land is very clear. The law of the land is applicable to everyone, that the individual freedom will trump over the innovation. And that is why this balancing act is required. While innovation is definitely the cornerstone of our growth, current India's growth story, and therefore cannot be allowed to be stymied to any extent, the individual protection of individual rights in the privacy being a part of it as well, will necessarily have to have slightly more importance, or has to be given a little more pedestal, would be placed at a higher pedestal than innovation, simply because of the fact that individual freedom or right to life, 1921, will have to be protected, because that's the law of the land. Even if one person gets affected because of breach of data, resulting in, say, loss of his life, loss of his reputation, loss of his financial wealth, he commits a suicide after losing everything, maybe after somebody takes the data and uses it for a purpose to harm him, then I think that will have to be protected under the constitution. That is the Indian constitution. But having said so, I would say that technology would always gallop ahead of regulations. Regulations will always lag behind. And therefore, what we are seeing currently is probably -2 delta x t minus 2 delta t0 kind of time. That is, it takes time to set up the laws and the regulations, but by that time the technology has already gone ahead. So this process will continue, and the laws will have to be necessarily amended and brought to that level. By that time, again, the technology may have gone ahead. Therefore, I compliment the pragmatic attitude, or the pragmatism with which the act has been brought out, contrary to what the EU GDPR has done. In the Act, the principles have been laid down. These principles have been derived from the Puttaswamy judgment: purpose limitation, data minimization, collection limitation, quality, audit, transparency. All these are basic tenets of this framework that has been retained. The rules, if they need to be changing with the technology, very easy, because you don't have to come to Parliament all the time. The regulations even would be easier, because the Data Protection Board will just take out notifications after notification. So I think structurally we are having a good thing, as Nappi said, and I have spoken in Parliament that it is one of the most landmark legislations that has come out in independent India. We should be happy about it. We should go ahead and implement it. There will be implementation bottlenecks and operational deficiencies and operational gaps, as in any law. And once the implementation throws out these gaps, they will either be taken cognizance by the executive and set it right, or it will go to the courts, who will interpret it in a particular manner. I'll make one last point relating to sectoral regulators. The Act and the Principal Act and the rules, they have left to the sectoral regulators to have a higher level of norms, and which is understandable, because what is required for the health sector cannot necessarily be something which will be required probably in the MSME sector, or maybe in the agriculture sector. Let's say agriculture, I think there, in an example, agriculture will not require the same level of personal data protection requirements as health of patients. In agriculture, I think innovation is something that has to be given much more priority over protection of agricultural lands details. But in case of patients, has to be completely different. But still, this balancing thing is why the regulations and rules are there. That is basically to develop trust in the system. And to develop trust in the system, it takes time. And once it gets well established, as I talked about the consumer protection, when it was introduced initially in 86, and then the latest version came in 2019 or 20, by the time the consumers had developed a trust in the government's act, in the system, that we have a law which will protect our rights. So that will also happen in this case. These are early times. We must celebrate the fact that at least this has come. And I think, to my mind, as she was saying, that EU is quite backward, and in fact that is the conscious decision that we took. Therefore, that we will not have a cut and paste of the EU GDPR, but we will have a law which is relevant to Indian context. We have to be cognizant of the fact that digital component is a very significant portion of our growth in economic terms, and therefore we cannot allow it to be pushed to the back burner. Thank you.
Thank you, sir. I think what you have talked about pragmatism and a kind of, being happy with at least something has come. The same thing along with the caps was elaborated by Ms. Nappinai. I want to, this is definitely a topic we can debate, but I really want Ms. Nappinai to, because you spoke about that, the law is in a way good about children's protection of their right and their everything. So Ms. Nappinai, India's age for digital consent is set as 18 compared to 13 in COPA and 13 to 16 in GDPR. And we have seen that, you are saying that this law is good with them and you are kind of pleasantly surprised about it. How do you think this higher threshold affects children's autonomy and digital literacy in an evolving digital economy, and what could be its implications?
The first thing that I believe that we have to keep in mind is access to the internet is different from access to social media or platforms.
Okay.
Often when we debate about age gating, these two issues get interlinked. So nobody is stopping access to the internet to a child. No one is stopping the possibilities of usage of an online medium for knowledge acquisition, right? We are only talking about knowledge or information sharing, I would say. And that also to a very limited extent, which is about personal data information sharing. And in that note, I would say that there should not be and there cannot be two ways of looking at it, that there is an innate requirement for protecting a child from sharing more information than they should about their personal details, and two, that it should be done in a manner where it is not stifling. You give them the opportunity, but at the same time ensure that there are protective ring fencing around or guardrails around what is being done. And often we will see that those guardrails will be breached. So then the criticality is, what are the kind of protective measures you can bring in ex post facto also. So these are the three steps we are really looking at. So at least we have not gone the drastic extreme way of Australia of banning social media itself or of chat apps, etc. We are only saying that it will be age gated through a parental consent. And that's just the same way as a supervision process which you would find in any other access methodology. Anything and everything that a child does, including either accessing sports, including any other extracurricular activity, or for that matter school itself, is predicated on parental consent. Certain things of course are mandatory like your education, but still it is done through a process of a guardian or a parent being involved. And I feel that's the philosophy that seems to have permeated the process of setting out the provisions and the rules for child data. Why I mentioned that the rules were a pleasant surprise is, see, when you talk about exempting data fiduciaries, I told you my concern always was it should not be such that it will actually impact the protection of child data through exempting certain fiduciaries for the purpose, even it could be even for innovation, it could be for AI, it could be for any other aspect, right? But where you see that the exemptions are clearly thought through in terms of health, education, those kind of criteria, where you know that it is essential to process a child's data to provide that particular service to them, I think that's a well thought through process. And the purpose limitation that has been built into the rules is again a criticality. Now, we spoke about whether the age should have been thought of as lesser. Now, when you look at the age at which you are expected to enter into a social media platform, from the platform's perspective is 13. From the Indian law's perspective is 18. So we are really looking at that period from 13 to 18, which is where the parental consent comes in. But in reality, we see that often children below the age of 18 also seem to somehow have a platform. And therefore, having a parental consent process in place for all minors becomes essential, so that, of course, I understand that humans are very, very creative, particularly when it comes to committing violations or circumventions. For every protective measure that the government or a platform will bring in, the human brain will think of 10 different ways to violate it. But we have to keep trying. Just because something can be circumvented does not mean we will not implement it, right? So we have to try, and I think we have a good start. But where I feel the rules really lacked was, I expected the rules to actually set out a process. It doesn't have to be technology specific, because then you would be stifling innovation again in terms of age gating also, right? So it is fine to leave it to the platforms to innovate age gating, but at the same time providing some basic standards in terms of what is expected was something I anticipated as being part of the rules, which I find to be missing. Whereas what is part of the rules is in terms of what kind of data will be collected to do age verification. Now, that is where I already mentioned my concern about the purpose limitation being included. I feel this is where the balance is. So I really feel that the world is going towards a process of putting in preventive and protective measures for children. And if India is leading, bravo to us.
So, just like another question which I sometimes feel is very important is also, as you had mentioned, or I think Dr. Patnaik mentioned, that we have to do. I think you mentioned about educating people about, say, when it was about consumer rights, that they were all provisions. So if you look at something like social media platforms, which we are trying to limit by the age of 13, I don't think there is any education in schools or anywhere which talks about it. And does this act as any provisions around it? Do you feel so? Or what should have been there?
Certainly, because now in India, we do have laws. I'll give the Sexual Harassment Act as an example, which makes it part of the act that awareness should be created about the provisions.
Yes.
So similarly, I feel that firstly, people have to understand their right of privacy. If you look at what happens, I see two extremes when people try to start a conversation with me about privacy, even in a social setup. One extreme is like they think their right of privacy is absolute and it cannot be violated for any reason, including even for law enforcement. And you have to actually explain to them that law enforcement is also part of our fundamental right of security and safety. And therefore, if that means sharing personal data, it has to be done. And that's a necessary exemption. Similarly, the other extreme is when somebody says, if you have nothing to hide, then what is your problem with sharing? That causes serious concerns.
It does.
That is not the concept of privacy. It is not, we are not asking for privacy because we have something to hide. We are asking for privacy because it is a fundamental right to be left alone. That's the classic Brandy's statement, right? The right to be left alone. Not because I have something to hide, not because I have done something wrong, but because that is what I want to be. And that right of being is something often many people do not understand. The second step, what you mentioned about children, and they should know not only about where the restrictions are, but also the consequences of violating those restrictions, because they are the best enabled to create those circumventions. They are much more technologically advanced than each of us are, collectively also. Right?
They do.
So therefore, explaining to them why the law puts in those preventive and protective measures, making them understand it's not a restriction but a protection, and that it is not protectionism, it's still only protection. So use it wisely, use it to the extent that's necessary, and don't overdo it is something we really need to explain without preaching. In fact, if you see the way I wrote Sassy Tales, the book on cybercrimes, I have followed that example. I personally feel that at best we can tell a child, if you touch fire, it'll burn. And then the wise child will keep away from fire. The inquisitive child may want to touch it to see whether it burns or not. So
Yes.
you have to provide that protective measure for all kinds of children, right? One who will wisely stay away, the other inquisitive child who will burn themselves, you will then provide the remedies for those burns. So that's the whole way of approach I believe in. Inform everyone what the consequences can be, and also explain to them what are the remedies available to them per chance if they exceed that, if they don't listen to the sensible advice or the protective measures and go beyond that. It's fine, that's part of life, right? So this is the way I think we should approach it. Even when you're talking about awareness should be without preaching is what I believe in, and I think that would be the most effective way. And hopefully, at least through rules, this is not something we need to wait for a parliamentary modification. I'm sure that we can build something like this into the rules also. And we should look forward to something like that.
I would just come to my last question was Usha Rengaraju about it. And I know, I thought this would be a discussion, but this is in a form of discussion. It's also a very good explanation of what exactly is there by three of you. One thing which I am really concerned about is the whole consent management thing. And Mr. Rengaraju, as you have just specified that, the companies which are here in India working, or any companies, if they are making a product for India, they don't care so much about it. So how feasible do you think it would be to implement these rules about consent management for in a country like India in such an environment?
Yeah, I think it would act as a blocker for several startups who are, who haven't even raised funding and, who are struggling to meet their day-to-day expenses and all these things. These kind of consent management might be like a cost overload for them for sure. But for a majority of big players, I think like the bigger companies, I think they should not be having any problems implementing these things, because there are already, I've just, after the rules had come out, I've checked if there are any third party softwares which which is at least closely mimicking these kind of implementations and things like that. There are already some kind of third party softwares out there, Turtle Board or something like that, which I saw. There are a lot of already third party softwares and tools which had come out. So it might be like customizing the existing softwares for them already with few more additional things, and plug in and plug in. So the bigger players who have a lot of money, I think it shouldn't be a problem for them for the implementations for sure. But again, I would say, see, India is a country with a lot of different background, diverse culture, language, diversity, and all of it. So I was working at projects in the intersections of language and diversity. For example, when you take the pension management systems for the government of India, for India, the problems are always scaling at that kind of a scale which the other countries don't have to deal with. So for India, we have huge number of populations, and for every 10 kilometer the culture changes, the language changes. Even if it's the same language, the accent at which you speak and the certain words which you use might differ. It could be the same language. So when it comes for this, when it comes for digitizations or converting into an AI product, there are a lot of challenges for this. Thanks to the AI innovations, especially if you see video processing, image processing, and all of it, right now we are in a good phase. We have not reached the 100% accuracy, or not even close to 80, 90. But there are a lot of startups who have already started implementing projects, AI projects and tools in this intersection. The feedback management system, the pension scheme management system, if you see, there are a lot of NGOs in Maharashtra who have already implemented a scheme where the the pensioners, if they want to, apply for the pension from the government of India, they just have to open an app. They have to just press a button. So for just opening a mobile app and pressing a button, data literacy is not required, or the person doesn't even have to be educated for just tapping a button. It's just they're using their hands. And once they tap a button, click on the button, the person can start communicating in their native language, in their own accent. So the questions, whatever the person records, there's a list of questions which will be given to him in the mother tongue. The person can respond in their own native language through voice. So the person doesn't even have to and have the understanding of typing or have to understand, do anything. They can just verbally communicate in their own native language. There are a lot of AI products which can take this local native language in their own accent, convert it into text, process it, and just with just voice answers, the system will automatically take all the answers, go out, fill the forms, and process it. So now everything has been made easy. So there are a lot of languages we are able to achieve this. We're not able to achieve 100% accuracy because we've not been able to build models outside of major languages like Hindi, and there are certain major languages where we are able to build a system capturing the nuances of the language. For the other local language, it is like capturing the language, converting it to text, and then taking the text, converting it to English, and then finding the answers, recording it, and all that. So there is bit of
Process.
room for errors and things like that. But at least there are projects which has kickstarted already. And some of them have completed these implementations in major languages like Marathi, Hindi, and things like that. So there are already systems in place, because one of the draft rules also mentions that they can get the consent in 22 other Indian languages outside of English and things like that. And for a country like India, the data literacy was always a concern. But thanks to the AI innovations which is happening in India, there are many startups who have already started tackling this problem of how to get the consent, or how to fill a form, or how to get the data from somebody who doesn't have data literacy and somebody who cannot type or read, but then they can just speak in their local language. How to get this done for these kind of people. So these are kind of innovations which is very crucial and important for a country like India. And thanks to AI, people have started addressing, but there is room for errors at this point of time. We have not, because the local language models, Indic language models, we have not achieved that kind of accuracy. But at least there's a kickstart in that direction. So I definitely think consent management is going to be a very complex problem to handle. But I think it's important that these rules have come out, and we've started taking digital data privacy and all of this very seriously. So these are my thought process in that. With
Thank you
regards to
so
that.
much. Thank you, all of you, to be here part of this discussion. We just wanted a kind of an understanding and a primer on the rules and your own opinion. And I'm thankful for your time, and we would again join on something similar very soon. Thank you so much.